in custody downstairs. Okay, are we running that?
No.
What are we doing with that? Did you want him brought up for that?
No, Your Honor, I can waive his appearance for that. I can go down.
On the record in the matter of the people of the state of Michigan versus Robert Wharton 25-00760 appearance, please.
George and on behalf of the people, Your Honor.
Yeah, thank you, Your Honor. Good morning, Jared Austin, appearing on behalf of Mr. Fortin. He is not present in the courtroom. He is present in the building and lockup. I would waive his appearance for the purpose of this proceeding.
Today was the date that was scheduled for preliminary examination. You don't have necessary witnesses, is that the issue?
Correct, Your Honor.
Okay, how do you want to proceed, counsel?
The defense would like to make a motion.
Your Honor, given that, Your Honor, I would ask that the matter be dismissed, understanding, of course, the dismissal is without prejudice as a matter of law.
Motion's granted. We'll get you a copy to bring down to your client.
Thank you, sir.
Thank you. On the record in the matter of the people of the state of Michigan versus Joseph Glavis, and I have a Stephanie Glavis 25-00708 and 25-00707. Appearances, please.
George and on behalf of the people, Your Honor.
Please, court, Your Honor, Attorney Frank Narita on behalf of both Mr. and Mrs. Glavis, who are with me to my immediate right.
Co-defendants, and they've waived any potential conflict to be represented by the same attorney, correct?
I've explained it to them and they have, yes.
Okay, today was the date that was scheduled for preliminary examination. How are we proceeding on this?
Thank you, Your Honor. The parties are asking for a brief adjournment for a potential resolution, resolution. Defense counsel is also provide our office with a memo or a mitigation letter, and we'll take that into consideration with any further reduction with the charges. A
week or two.
We could do being requested, Your Honor.
Okay, so Mr. and Mrs. Glavis, you understand that you have the right to have a preliminary examination within 21 days of the date that you were arraigned?
Yes.
And you're willing to waive the 21-day deadline so that we can reset this?
Yes.
Is anyone forcing you to do that or threatening you to do that? Okay.
April 11th at 9.
April 11th at 9. Additional matters for today's record.
No, Your Honor.
Nothing further, Your Honor. Thank you very kindly.
No problem. We'll get you a copy of the notice to appear. Record in the matter of the people of the state of Michigan versus Ariana Stevenson 25-00202. Appearance.
George and on behalf of the people.
Good morning, Your Honor. Gidget James on behalf of Adjournment Stevenson, who is approaching the podium and will be to my right.
Ms. Stevenson was scheduled today for preliminary examination for a delivery manufacturing of substance, weapons, version, firearm, felony firearm that is, and maintaining a drug house and delivery manufacturing another count and another felony firearm. I understand that there's going to be an unconditional waiver today.
Correct.
That's correct, Your Honor. I would like to offer by the people placed on the record.
Possession less than 25, dismiss the balance.
Okay, and ma'am, you understand you have the right to have a preliminary examination in the district court on these charges?
Yes, ma'am.
Do you understand that the purpose of the exam is so that you can require the prosecution to first meet their burden to establish that there's sufficient probable cause that the felonies were committed in probable cause sufficient to charge you as the person who committed the felonies.
Yes.
Do you wish to unconditionally waive your right to an examination today?
Yes.
Anyone threatening you to do that?
No.
Has there been any promises extended to you, not placed on the record, that are you considering to make you want to waive your exam? The bind over date is April 9th. That's the date the circuit court takes the file from the district court. You do not have to appear in circuit court on that date. You understand that?
Yes.
Your next court date will be a pre-trial in circuit court. Your attorney will be made aware of that date. Do you have any questions? You still have the address on Victor Ave?
Yes.
Still ask for it of your phone number.
685.
Whose number ends in 4466? Is that your number as well?
That was the whole number.
Oh. A bond was set at 3,000 personal recognizance with a random weekly PBT and twice a month ETG. That will continue. Any additional matters for the record?
No, Your Honor.
Thank you. You're all set.
All right, thank you.
Miller is a waiver.
Correct.
Miller can be brought up. Begin with Stephen Bonham. Stephen Bonham here.
Yes, he's in the hallway, Your Honor. We would be running if the necessary was here.
Is the witness here?
No.
On the record in the matter of the people of the state of Michigan versus Stephen Antoine Bonham, 25-00421. Council can have your appearance.
George, and then have to be there.
And thank you, Your Honor. Good morning, Jared Austin, appearing on behalf of Mr. Bonham. He stands present to my right.
Okay, Mr. Bonham, today was scheduled for a preliminary examination on home invasion first. There was an electronic communication and a domestic violence misdemeanor that accompanied the file. My understanding is that the necessary witnesses failed to appear.
Correct, Your Honor. I tried to reach out, had some sort of contact with somebody related to the necessary witness, but at this time, the witness did not appear despite information that she was going to appear.
Mr. Austin, how do you want to proceed?
Given that, Your Honor, I would ask the court to dismiss the matter against Mr. Bonham, understanding, of course, the dismissal is without prejudice.
Your motion is granted. That means for you, Mr. Bonham, that the people do have the right to reissue this charge against you. You understand that? Do you have any questions at this time? I'll get you a copy of dismissal in just a moment. Sentencing file for Ariana Ash.
We off the record.
Oh, you're all set.
Okay, thank you, Judge.
Okay, for some reason, Zoom booted us out, but we're back on. And this is the matter of the state of Michigan versus Ariana Ash. Counsel, can you start your videos and put your appearance on the record? Mr. Yang? Appearance for the record.
He did send me a message that he couldn't hear, but I thought that's because you were muted.
I'm not sure. Ms. Wanji, can you hear me?
I can hear you, Your Honor.
I can hear you now. I apologize. I changed some settings and I was able to hear you. I apologize for that.
Thank you. Appearance for the record.
Joseph Yang on behalf of Ms. Ariana Ash. We are both present via Zoom and consent to this hybrid hearing.
Okay, today was the date scheduled for sentencing. This is for attempted plea and eluding charge that Ms. Ash pled guilty to. I do have a pre-sentence report. Those were prepared on March 17th. Counsel, did you get a copy of that?
Yes, Your Honor, I did receive a copy of it. I provided a copy to my client. We have reviewed it, and there are no additions, corrections, or deletions. We would like to address one condition, though.
What is that?
So Ms. Ash does currently have a valid medical marijuana card. She provided me a copy of it. It was issued on 5/10 of 2024. So it's prior to this incident. So I'd like to request the court allow her to use her medical marijuana card as she does have a valid one at this time.
You would have to provide it to probation.
Okay, thank you, Your Honor.
You can make allocution.
Thank you, Your Honor. I believe Ms. Ash is a great candidate for HIDA. The probation department also agrees as well, and that is their recommendation. I would ask that the court just follow the recommendation in the PSI. Ms. Ash understands her actions, and she should have reacted differently that day when officers attempted to stop her. But I believe she's somebody who is contrite and is somebody who would benefit from the HIDA probation. So I'd ask this court grant that to her. Also, I'd ask the court to waive as many of the fines and costs as possible. As she is indigent, I am conflict counsel through the public defender's office. Thank you, Your Honor.
Did your client want to make a statement?
Ariana,
No,
did you want to?
No, I'm okay, Your Honor. Thank you.
I reviewed the pre-sentence report and the recommendation, as well as review the prior criminal history and background information for Ms. Ash. Ms. Ash, you're very young.
Yes.
You're just starting your adult life, and it seems like you've had a bit of a rocky start. You're already on probation right now, at least you were at the time of your sentence. Is that correct?
Yes, I'm off of probation in Ian County now, but I was at the time of my sentence.
Oh, okay. My notes said you were to be on probation until June 2025. So you got off early?
Yes, they let me discharge early from probation.
Well, that's a good sign for you, because that means you've been compliant with probation. And so I believe, and I recognize the information that you provided during your plea, but also the information that you shared at the time of your interview with our probation department. I believe that you are likely, or at least in this situation, you were a victim of poor judgment due to the company that you've been keeping. And so hopefully, these last couple of months, or last year to be exact, due to the involvement that you've had with the court, being so young, that maybe you've made some different decisions about who you're gonna hang out with. Because the court's gonna give you an opportunity to redirect your path with a special status under the Homes Youthful Training Act. But that will do nothing for you if you continue to fraternize with people who are on the wrong side of the track. Do you understand that?
Yes, ma'am.
So you want to make better decisions, and the first decision it looks like you should be making is being careful about the company that you're keeping. I think that will help you not be back before the court for any actions such as the ones that you've been here for in the last year or so, even this court and in the court in 56A. Nonetheless, I think that the recommendation is appropriate, that you would benefit from a brief term of probation.
Okay, thank you.
I'll adopt the recommendation, and you will be sentenced to a term of 6 months probation. While on probation, you have the following conditions. You're not to engage in any assaultive or threatening behavior. You're not to possess or purchase a firearm, ammunition, or weapon of any kind. You're not to use, possess, or purchase alcohol or marijuana unless you have a valid prescription. Once you turn over a copy of your medical marijuana card to probation, that will satisfy the medical marijuana aspect. I also recognize that you do work at a bar and grill. So possession of alcohol as it relates to doing your work is obviously allowed, but not possession for your personal consumption. Do you understand that?
Yes, ma'am, I understand.
Okay. And so I'm not going to order at this time for you to submit to PBT and or your analysis, and that's completely due to the fact that you were just on probation and that you did so well that they discharged you early. So I don't think we need to monitor you for alcohol use at this time.
Okay.
Let's see. If something changes, then my order could change. You're not to be at any bars or nightclubs while on probation. You're going to maintain your employment. Are you working full time?
Yes, now I am. I'm working like 5 days a week, but it's not considered full time because I do work at a bar, or like I'm a server, so it's considered part time.
Are you looking for full time employment?
No. I work 5 days a week, so like I make like full time money, but I just don't work full time hours.
Okay, sounds good. Okay, let me see here. What's going on? I'm going to order that you complete 40 hours of community service. You'll get the full 6 months to complete that. However, I need half of those hours to be completed at the LMTS Outreach Center, okay? You're gonna contact Josh Gillespie at the LMTS Outreach Center and let him know that Judge Simmons is sending you there for some community service. So 20 hours needs to be performed there, okay?
Okay. And then the other 20 hours can be anywhere for community service?
You can get a list from probation as to where you can select to do your other 20 hours.
Okay.
Okay. You'll maintain your employment and provide evidence of that to probation. As to probation oversight, there's a $30 per month oversight fee that you have to pay for each month of probation. 6 months of probation is $180. A $75 crime victim rights fee that will be assessed. There's a $50 state minimum cost that will be assessed. I'll waive discretionary fines and costs. Your total fines and costs will be $305. You'll make monthly payments on that, okay?
Okay.
Sounds like you're familiar with your right to request early discharge from probation. Is that correct?
Yes, ma'am.
Okay. And so you can make that request after 90 days of this probation, so long as you've been compliant. So if you get all your community service done early, because that's the only thing I ordered you to do, you can make a request as long as you've not had any violations to be discharged early after 90 days. If I didn't say it, I formally am saying it now. I have granted you HYTA status. Do you have any questions at this time for the court?
No, ma'am.
Okay, you can or should report to a probation so that you can check in and make sure they have accurate contact information with you over the next couple of days. You can do that electronically. You don't need to do that in person. And once my order of judgment has been drafted, they'll send it to you for your signature and review, okay?
Okay.
Any additional matters for the record? Counsel?
Nothing from the defense, Your Honor. Thank you.
Thank you. You're all set, ma'am.
Thank you.
You're welcome. This is Tyler Miller.
Yes, ma'am.
Okay, State of Michigan versus Tyler Miller, 25-00716. Appearance, please.
George Danette on behalf of people, Your Honor.
And thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Miller. He is present with me at council table.
Okay, Mr. Miller, today was the date that was scheduled for preliminary examination, and I have a notation that the parties are doing an unconditional waiver today. Is that accurate?
Correct, Your Honor.
It's my understanding as well, Your Honor.
Was there an offer?
Count one with dismissal of the habs.
That is my understanding of the current offer as well, Your Honor. I've conveyed that to Mr. Miller. We will continue to pursue negotiations at the circuit court.
Mr. Miller, you understand your right to a preliminary examination?
Yes, ma'am.
You understand your right to require the prosecution to establish, you can have him sign this, establish sufficient probable cause that a crime was committed and probable cause sufficient to charge you as the person who committed the felony.
Yes, I do.
You wish to unconditionally waive your preliminary examination?
Yes, ma'am.
So anybody can okay. Next court date in circuit court is going to be a pre-trial. Bond in this matter was set at 2,010%. That will continue. Any additional matters for the record?
I think additional on behalf of Mr. Miller, Your Honor. Thank you.
Thank you. You're all set.
April 26th.
Mrs. Wanji is here with, is it James Nicholas?
Yes, Your Honor. May I
Okay, are we
speak
ready
with
to,
him, Your Honor?
you need to speak with them privately?
Yes, Your Honor, please.
We're having some glitch or something with Zoom. It keeps booting the courtroom out. I don't know why, so let's see. I don't know that, let's see. We can see breakout room options in here now. Am I the host? Who's the host? There's two of who, me? Not in mine. No, we have me up there once. Oh, gosh. I'm not the host. I don't know who's the host. Your other. I don't know what the other one. I don't have another. It's just, that's the only one I have. Okay, this is what we're gonna do. I'm gonna leave. Yeah. And we're gonna start all over. It's great. Mrs. Donnelly. I like your haircut. Let's see here. You had,
I'm Luke today.
okay, Goodrich. Josiah Kane, are we running that?
No, we're waiting.
Okay. Okay, there's co-defendants. Okay, on the record in the matter of the state of Michigan versus Josiah David Kane, 25-00719, appearance case.
Resident of Madam People.
Assistant Public Defenders on behalf of the Attorney of Record Luke, Assistant Public Defender Sarah Donnelly on behalf of the Attorney of Record Luke Goodrich for the defendant Josiah Kane, who is standing to my right.
Okay, today was the date scheduled for preliminary examination, and my understanding is both parties are unconditionally waiving. Is that correct?
Correct, Your Honor.
Yes, Your Honor.
You're an offer.
Count one, dismiss the balance, forfeiture of the firearms.
Hey, Mr. Kane. You understand that you have the right to have a preliminary examination on the felony?
Yes.
You understand the purpose of the exam?
Yes.
You said that the offer was to plead guilty to count one.
Correct, Your Honor, CCW.
Okay, so you have the right, sir, to require that the prosecutor first establish sufficient probable cause that the felonies were committed, and then probable cause sufficient to charge you as the person who committed the felony. You understand that, right?
Yes, ma'am.
You wish to unconditionally waive your exam?
Yes, ma'am.
Is anyone threatening you to do that?
No, ma'am.
Is anybody making any promises to you if you waive your exam? You understand it's unconditional? Okay. Your bind over date is April 9th. That's the date the circuit court gets the file from the district court. You do not need to appear on that date, okay? Your next court date that you will have to appear for will be a pre-trial. You're still at the address on West Saginaw,
Yes.
and your phone number ends in 0090.
Yes.
Bond was set at 7,500 cash surety. That will continue. Any additional matters for the record?
Oh, yeah, thank you.
No, for defense, thank you.
You're all set. sir. On the record in the matter of the people of the state of Michigan versus Prentice Smith, 25-00720. Yes, please.
George and Ed, on behalf of the people here.
Yes, please, the court, David D. Carter Jr. on behalf of Mr. Princess Smith, who is present and standing at council.
Mr. Smith. Today was your date as well. Have a preliminary examination. Carrying concealed weapons, police officer, assault, resist, obstructing, and felony firearm. And my notes have that there's going to be an unconditional waiver on this one too.
Correct, Your Honor.
It's an offer.
Yes, Your Honor, it is count 1 CCW, dismiss the balance, forfeiture of the firearm.
That is a complete and accurate statement.
Mr. Smith is Prentice Smith Jr., correct? Okay, you understand your right to an exam, is that correct? You understand the purpose of the exam? You want to unconditionally waive it? Anyone threatening you to give up your right to an exam today? I'm sorry? Any promises being made to you if you give up your exam? Very soft voice. Is it normally that soft? Oh, okay. Find over dates, April 9th. That's the date the circuit court gets to file from the district court. You do not have an appearance date on April 9th, okay? Your next date in court was going to be a pre-trial. Your attorney will make sure you're aware of that date, so long as you stay in contact with them, okay? And I see an address for you on Rio Road that's still accurate.
Yes.
And a phone number ending in 6353. Bond set at 3,500 cash surety will continue. Any additional matters for the record?
Oh, yeah.
No, Your Honor.
Thank you, you're all set.
Thank you.
Ms. Schroeder,
Yes, Your Honor.
you have Ariana Larkin with you?
I do, Your Honor.
Great. Do we have that file? On this one or another one?
It's another one.
It's here?
Yes.
On the record in the matter of the people of the state of Michigan versus Ayana Larkin 23-03218 FT. Council appearance.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Miss Larkin, who is present and now stands to my right.
Okay, Ms. Larkin, did you forget you were supposed to be in court 2 days ago?
Yes, I did. I apologize for that. I had just had my daughter on February 14th due to my other daughter's birthday on the 21st. So I literally.
Mom brain.
No, literally. And I literally was counting on the 27th and I forgot about the 25th. It's honest to God, like brain fog. I apologize.
And I will note, Your Honor, I think this is a testament to Ms. Larkin, is that as soon as she heard about this, she was like, I'm still coming, obviously. I'm like, okay, cool. Even though she knew she had a warrant on the other file for failing to appear, she's like,
Well, it would make sense. It's sooner you come and when you turn
Exactly.
yourself in, we're not putting you in jail. It's soon we gotta catch you outside,
Yes.
that it gets difficult.
I'm just trying to change my whole criminal thing around.
I would hope so. Sounds like you have a very fresh baby at home that you need to be with.
Yes. So
Okay, sounds good. So this was an OWI. It was, is this a city or state?
But there was, the city case is the one that she FT or failed to appear on Tuesday for, and then she has the felony file. Plea elude, yes, he attempted.
The city one, I know we're supposed to adjourn it like 2 years ago for a substance abuse assessment. I don't know. I think the issue, well, the note I have here at least, when she saw the magistrate in January, it said she was 8 months pregnant. So I don't know if there's been a new offer on that. So we'll set this for another pretrial. Watch the warrant.
April 15th at 9:30.
April 15th at 9:30 for your city case. Then on the matter that we're here for today, it was for sentencing. I do have a pre-sentence report that was prepared on March 17th. You got a copy of that, counsel?
Yes, Your Honor, and I have reviewed it with Ms. Larkin. There is one correction to be made.
What is that?
It would be, oh gosh, I could have lost. It would be actually on the pre-sentence investigation questionnaire. It looks like there was a correction made on it. Under alcohol with substance abuse, it's its last date of use was February of 2025. That should be 2024. Because
I would imagine
yes,
she was about to give or had given birth.
yes,
Oh,
so
yeah, I don't see where that is.
it was on the questionnaire, so I don't know if you really,
Oh, okay.
because that's what was, because I did ask her about that and she indicated, oh, no.
I was supposed to be induced filling this out, so I was under a lot of pain. My apologies.
Oh, I see that. Okay.
But other than that, that was the only thing we wanted to clarify.
Looked like everything had a 2020 and then it was written over. Okay, sounds good. 2024. Okay, you can make allocution.
Thank you, Your Honor. As Ms. Larkin has stated a moment ago, she is really looking to take responsibility for these bad decisions and trying to get everything back on track. She has 2 young children now. She has a 5-year-old who she indicated earlier that she had recently had a birthday with, and then a newborn birthday of February 14th, 2025. I'd ask the court to adopt the recommendation, allow her to serve a term of probation with Zoom reporting. She has indicated to me she has actually an assessment that is scheduled with regard, she got that set up to handle with regard to her city case as well, April 7th at 8:30 with MMRS. So she is taking a lot of initiative here. I know that these cases have been pending some time, but she is also avidly looking for employment. Hopefully something work from home. So she's been putting in applications pretty much every day, trying to find something that she can do while she's still recovering, especially. So I'd ask the court to follow the recommendations and allow her that opportunity. Thank you. And with HYT.
What is her assessment again?
April 7th at 8:30 a.m. It would be with MMRS.
Does your client want to make a statement at all?
No.
Okay, let's. So I reviewed your pre-sentence report, your prior criminal history, which there were no other convictions there. And I believe that the recommendation is appropriate. States that you were respectful during your interview, that you remembered accurately the incident, and that you attributed to your involvement with uses of certain substances during that time. And although we don't necessarily have an assessment report at this time, I think we know unequivocally that you could benefit from some resources as you're stepping into this new chapter of your life with your new baby and your 5-year-old, to be clean and to be sober and to be there physically and mentally in a stable condition for your children. And so once that report is generated, even for the city case, I'm ordering that the report goes to probation for this file as well, so it can be released for this file. And if they determine that any additional treatment could be beneficial to you, my order could potentially change. Do you understand that? At this time, I'm going to sentence you to 12 months probation. While on probation, you're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind, and you're not to use or possess alcohol, marijuana, or any other controlled substance unless you have a valid prescription. Do you understand that?
Yes.
I recognize that you just gave birth, and so you're not just ready to go into employment at this time. However, once your maternity stay has ended, you will be expected to maintain employment, okay?
Yes, ma'am.
I'm gonna grant HYTA status. You will be required to submit to random preliminary breath testing and urinalysis testing and pay the fees associated with that. You're not to be at any bars or nightclubs while you're on probation. You understand that? I'm not gonna order any formal treatment at this time because I think we need to get a report. See what we need to do. This is a matter that happened in 2023. So it's not something that just recently happened anyway, so. And then you just gave birth, so. Let's see. There's a $30 per month oversight fee that you are responsible for each month of probation. And so if you do 12 months, it's $360. $75 crime victim rights fee that will be assessed, and a $50 state minimum cost that will be assessed. I'm going to waive discretionary fines and costs. So your total fines and costs is $485. You'll be able to make monthly payments on that. I recognize that right now, it's probably tight for you with 2 children and not working at this time. You should be prioritizing, if your finances are limited, your testing at this time. So that you can get that done, so we can know that you're remaining, clean and sober. And then at the end, we can always address the fines and costs later, or you can pay them off when you're working. But prioritize that if money is an issue, okay? Do you have any questions at this time? When you leave here, I want you to go down 1 floor to check in with our probation department so they can make sure they have active contact information for you. Lastly, there's an advice of rights as to probation that I'm gonna have you initial. I'm gonna go over the rights with you now. It states that you have the right to request early discharge from probation once you've completed half the original term ordered by the court. So in this case, after you complete 6 months, if you've not violated within the 90 days preceding that 6 months, can you give this to her, please? And if you've not had any, then you've completed all the required programming. And at this time, we have not given you any, but if you were ordered to do maybe outpatient or something, if you've been compliant and completed that, you can request to be discharged early, okay? You would use the court's MC 512 form in order to make that request. If I set up for a hearing, you have the right to hire an attorney to represent you for that purpose, but you don't have the right to court-appointed counsel for any hearing for early discharge. I've never held a hearing for early discharge. I just review the request off the record, okay? And do you have any questions about those rights? Any additional matters for the record, counsel?
No, Your Honor, thank you.
You can put her signed advice of rights.
Let's see.
Sign at the bottom, Your Honor.
Yeah, right at the bottom.
Yeah. You're down.
Ms. Wanji, can we bring your client up the breakout room?
Your Honor,
Yes, Your Honor.
so I'm clear. We did grant HYTA status. You did grant HYTA status. Is that
I
correct?
did.
Okay, I just want to make sure I wrote that down correctly. Thank you.
You're welcome.
Thank you.
You're welcome. Good luck to you, man.
All right, take care of yourself. And those who did that, and that
Thank
other day.
You guys have a great day.
Same to you. And we'll see you on your other court date.
And I will let them study and I will let you give the date and time for that. Okay.
I don't know why.
You said 1 course to level 5, right?
Yeah, she's got to actually help me out getting down there.
On the record in the matter of the people of the state of Michigan versus James Ryan Nicholas, 25-00195, 25-00211, and 25-00195. Again, council appearance.
George, did it end up having people, Your Honor?
Good morning, Your Honor. Melanie Wanji for Mr. Nicholas James Nicholas.
Thank you. James Nicholas is present via Polycom from the Ingham County Jail. Today was the date that was scheduled for preliminary examination and a contempt hearing. Let's see, I believe that my understanding is that there was an efforts working to get him into a treatment court. Is that accurate?
Yes, Your Honor. I believe yesterday I emailed 54B probation in regards to drug court. Defendant has 2 other files, I believe, that was referred. He went into the wind. He's back. I screened him for legal eligibility. He is legally eligible still. I believe our office, or I'm sorry, 54B probation with the drug court is supposed to reach out to him at some point, screen him again, and see where we're going from there. So we're asking 2 to 3 weeks out for that to happen.
Okay, and we do not need to address timeline on this, so we can just reset this.
April 24th at 10.
April 24th at 10.
Thank you, Your Honor.
Thank you. Let's see. Any additional matters on these files today?
No, Your Honor.
Your Honor, my client would like to address bond, and he would like the court to consider releasing him on a terror bond. He has some medical issue that he would like to address, in a very urgent medical issue, and also he explained to me that he will check with pretrial services. He didn't have a phone, but he would use someone else's phone to check with pretrial services, but the terror will allow him the court to know anytime where he is at, but he needs to go to the hospital to check for some medical issues.
Failing to appear yesterday. Oh, on another file.
The reason I feel
Why is it? Hey, stop talking, please. What is that?
sorry.
That's me.
Yeah.
I don't know. It was arraigned yesterday.
No, that was yesterday. That's the 26th.
He orders arraigned him yesterday on the. new
Oh, is
charge
that what
in
that
the tip
means?
hearing. I don't know why he put go to it.
Yeah, because I was confused, but it went 2-5. Okay. It doesn't make any sense. Okay, got it. Sounds good. Okay, it looks like he was just arraigned yesterday by Flores. Is that correct?
Yes, Your Honor.
And since yesterday, when a judge set bond, we need to now change it because of what changed since yesterday.
So I was asking yesterday too, and he told me to just bring it up at court today. The only reason I missed court is because I was being held. All right, sorry, but yeah, I brought it up yesterday.
I have concerns about releasing your clients. And that's because it's been a long time just getting him to this point. We couldn't even arraign you, sir, because of your mental health crisis for a long period of time. And so you have a very low bond. It's not high. 2,010% is the bond. Very low in consideration to the charge. And the other bond I believe you have is a 3,500, 10%. Literally less than 7 days ago, my understanding is that, not even 7 days, earlier this week, my understanding is that you were experiencing mental health crisis. So no, I'm not going to amend your bond.
It wasn't mental health crisis.
You are able, oh, well, the judge wasn't in jail with you to explain what the mental health crisis is. I just get advised of what's going on while you're in the custody of the jail. And so there's been a history in my records of having issues getting you arraigned.
No, I was trying to say that the only reason I missed court is because I was literally being held against my will. Stuff happened to me that I had to get checked out in the hospital for. What happened?
I don't know.
So, are they still gonna try getting me into a rehab? Can you hear me?
We are on the record, so we can talk about that later.
Well, I wanna ask her if I can, if it's available, if I can go to a
Mr.
rehab.
Nicholas, everybody's listening to the conversation.
It's
Okay.
fine, it's fine, it's fine. I still wanna ask her if it's available, if I can go to a rehab.
It's obviously not me. Okay, there it goes. Okay, we got booted again, but we're back. A bond will continue in these matters. I will also be resetting the contempt hearing for the April 24th date. Any additional matters for the record?
No, Your Honor, thank you.
Can I ask one thing?
You may.
If there's a bed available for a rehab, can I still go to a treatment program?
Absolutely. If there's a bed available, your attorney will make a motion to the court to have it addressed so that you can be released directly into treatment, okay?
Okay,
Real
Well,
brief, my understanding that last time this happened, he was, I think the jail accidentally released him, and that's why he went on the run. So I don't know if that's even a good idea.
Oh, okay. Well, sounds like that's an issue that the court was not aware of. Okay,
They
you
didn't
talk to
release
your
me
attorney.
for-
You talk to your attorney off the record, okay, sir? You're all, you let the deputy know you're all set.
Thank you,
Thank you,
Yana.
Ms. Vaughn. Thank you. Hi, Ms. Marquita. On the record in the matter of the people of the state of Michigan versus Edward Mcole, 4-03139. Appearance, please.
George, and then I'm having people.
Good morning, Your Honor. Michael Anderson on behalf of Mr. Edward Mcole, who does appear personally and to my right.
Okay, Mr. Mcole, how are you?
Am I right?
Today is the date that's scheduled for a preliminary examination on criminal sex crime in the 4th degree. I have an offer here. It says the defendant's being offered to plead guilty to added count 2 of aggravated assault, MCL 750.81A, and that the people will dismiss the original count 1. There's a Killebrew agreement of no upfront jail, MRT during a term of probation, and no contact with the main victim. Is that complete and accurate?
All fair and accurate, Your Honor.
It is, Your
Okay, can you complete an advice of rights form, please?
Yes, Your Honor. We did provide the court a plea agreement, which does go through our acknowledgement of rights. You would still like.
And that's where we have those.
Understood.
Do you want to report Zoom? I sure do. Then we need to bring up Sanderson.
Yes, Your Honor, it's gonna be a request for the adjournment.
You can bring him up.
Lawrence is having the same issue.
I would imagine we are all having the same issue. Unless, well, actually, we are on 2 separate buildings, so they might not be, but it's booted us out of Zoom 3 times so far. That's the same as the first page.
Yeah, it's the same.
Okay.
Yep.
Oh, yeah, all right.
Thank you. Okay. I'm back on the record. Mr. Mcole, please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, I do.
Okay, you can put your hand down. You understand that you have the right in this matter to proceed with your case and proceed all the way through to trial.
Yes,
You have the right to require that the prosecutor prove each element of the charge being brought against you beyond a reasonable doubt. You can maintain your silence and not have that silence be used against you at your trial. You're presumed innocent until they prove you guilty. You understand that?
yes,
That if you give up those rights, you'll also be giving up your right to call witnesses that will testify to your defense or on your behalf. You also give up the rights to cross-examine at trial any of the prosecution's witnesses. You understand that?
yes.
So you want threatening you to get you to waive these rights and plead guilty today
No, Your Honor.
to the amended charge? Okay, any promises being extended to you if you waive your rights and plead guilty to the amended charge?
Well, just there'd be no upfront jail and no sex offender list.
Okay, and are you pleading guilty to an aggravated assault because you believe you're guilty?
Per the agreement, yes.
And that's not my question.
Uh,
My question is, are you pleading guilty because you believe you're guilty? That's a bit, like, don't look at him like that. He's got to make that honest answer on his own and not under duress of your stare.
I understand. As it was defined to me, yes.
Okay. As to the amended count, oh, well, first, before we get there, you understand that by entering this plea to aggravated assault, you may have to report it to your employment, or you may need to put this on a future job application.
Yes, yeah.
It also could have impact on where you can travel or get immigration status. So you might want to go out the country somewhere, and that country may deny you entry because of this conviction. You understand that?
Yes, yeah.
Okay, as to the amended charge of aggravated assault, how do you plead?
Guilty, Your Honor.
Factual basis.
Thank you, Your Honor. We'd be using the factual basis from the original charge in this matter in order to, Mr. Mcole, were you present at AutoZone located at 4725 South Cedar Street in Lansing, Michigan on or about January 5th of 2024?
Yes.
And is AutoZone located in Ingham County, state of Michigan?
Yes.
On that date, did you intentionally touch Miracle Hayes on the buttocks?
Yes.
And when you touched Miracle Hayes on the buttocks, it could reasonably be construed as being done for a sexual purpose, correct?
Yes.
Nothing further, Your Honor.
Satisfied, Your Honor.
Court is satisfied with the factual basis. I would accept your plea. I find your plea to be freely, voluntarily, and intelligently made. The matter is set for sentencing May 22nd at 9 a.m. When you leave here today, you need to go down one floor to our probation department. You're going to check in with them so that they can get you prepared for a pre-sentence interview, okay?
Okay.
They will get some information from you. There'll be a questionnaire that you must complete, and then they'll set you up for an interview that you need to return to for them to prepare a report and recommendation as to how you are to be sentenced, okay?
Okay.
Do you have any questions, sir?
Will the sentencing be here in this courtroom?
It will.
All right.
Okay. Any additional matters for the record?
No, Your Honor.
Okay.
Thank you, Your Honor.
We'll get you downstairs in just a moment.
Thank you, sir.
It could be used against you in the trial of the case. It's we talked about. We were trying to get out to talk to you yesterday. So you can have Mr. Carter, you can't have both. Okay.
I haven't heard.
Okay.
You got a shit show.
Well, I will make a note of that. What I'm getting at is, I know you want to drop. I know you want to. But I thought so. But
I have a two students. It was one big ones. You would understand. I just.
Okay. But it's not.
Didn't know how I don't know how to the case of no. I don't know. So I just said, I'm doing. But I said, you know, to whatever case we got. This was this mess. If you have an issue. That's it. It's like it can go into so much. Cases there's nothing you know. Send an email, forget about it. Yeah, I know. I'm saying if just for us, whatever. What can you do?
Oh, yeah. I know. I got an interpreter.
Came in for what?
So I've also just found out that. No, it doesn't.
Get back.
But because
Oh, then.
I have a, I could have been. Yeah.
Is it extra?
I think so. That was just.
Hang on. Let me get that if you want to get it from Mr. Freeman, because I know.
I told him.
Yeah.
And he was like.
All right, there you go.
So,
Okay, I got you.
I mean.
On Friday. Don't know about what that one. After you know,
I'm planning on it, that is my goal, and then next week, after Tuesday. Judges out.
Talk to.
I think nobody's gonna go in, I'm saying.
I think, yeah, I think.
20
I
hours a
may-
year, you know.
Yeah, I think I may ask Joel if I. Yeah, and just be like, listen, I work with off, I'm not taking the days off. I just want to be out of the office.
Yeah.
Because it's so hard to-
Oh, man.
It's just a matter of- I think I have.
Which again, nothing to do about it, just like, one thing, tell them it's
Okay.
for some reason, I'm managing.
Well, I can only do it. Okay, I will look into
Going
it.
on,
I can make it
myself,
okay.
I,
We are
it's all that.
not, it's more of a civil issue. There's a police report. We are-
So smooth. I had no issues since I started. Like not a single issue. I don't, I mean,
Okay. Okay, just. You gotta stop. Well, we talked about this stuff. I hear you, okay? Okay, that's fair. That's fair. That's fair. That's fair. You're right. Okay, that's fair. You're right. Okay. Yeah, okay, I got you now. All right, that's fair. Thank you for telling me that. That is fair. I hear you. I just. That's so much still coming in.
You could.
And it's just like I'm trying to get all the evidence together.
So I'm just kind of hoping to look at me on the butt.
Who's it? I can't buy you. Well, could it be brought up? Yes, but then you're not.
Yeah.
You're not discussing it. Really?
Yeah, I like the day he was arrested. I don't know, I haven't looked into it.
I don't know. People like it's nothing nowadays. You get on, stay on bond and just jump. Yeah, I'm not sure if it's fair or not, but you're sort of like.
Yeah, I got you. I got you. I'm listening. Just got right now, so.
All right. Okay, are we ready?
Yes.
On the record in the matter of the people of the state of Michigan versus Stephen Sanderson, 25-00744, appearance, please.
George, and then about the people.
And Assistant Public Defender Aaron Schroeder, on behalf of Mr. Sanderson, covering this morning for new assigned counsel Stephen Freeman. And Mr. Sanderson is to my right.
Okay, Mr. Sanderson has a domestic violence, a breaking and entering without owner permission, and a PA 53 contempt. Looks like he has another file pending, 25-00879, that has a probable cause conference next week. So let's see. Is it one violation or three? It's three violations. Looks like he was arraigned on that. Okay, how are we proceeding today?
Aaron, parties are moving to adjourn this case, have it at the same time as the other file. So the victim doesn't have to come twice. It's my understanding it's the same victim on both files.
Yeah, I mean, it is the same victim. Our reasoning was different, which is why I reached out, but the defense's reasoning would be the fact that we do have a new attorney who is subbing in because the new file was given to Mr. Freeman, and then our admin decided to sub him in on my file as well. In addition to that, the violations that are alleged on the PA 53 on this file are connected at least somewhat, potentially a lot more than somewhat, with regard to the new file. So there's also some intertwining here at this point of the two files.
I have the new file. No, I mean, it's before me.
Yeah. Yes.
Oh, okay. Okay. So both parties are in agreement with the timeline issue, okay? That's accurate.
That is accurate, Your Honor, and I have discussed this with Mr. Sanderson. He understands the reasoning. He doesn't exactly agree with all of it, but he also understands that it is to his benefit, is my understanding from speaking to him, because
he doesn't agree with
with
running them together. Is that what you mean, or?
He didn't understand it, and I believe he does now understand it, but I think he was a little confused, I guess.
Okay. You understand now what's going on?
Yeah, I'm just not an attorney, so it takes a minute for it to kind of.
That's why,
you know,
that's why she's here.
right, well, that's.
No one, there's no expectation for you to be an
I
attorney.
just had some more questions.
Absolutely, and sometimes it takes a little bit more than a quick 2-minute rundown, in the corner of a courtroom for you to register, or for you to be able to get all of your questions answered. So I completely understand that. For the reasons stated on the record, I'm going to go ahead and find good cause to adjourn this matter so that it can be reset, that gives time for your new attorney, or for the change in the attorney issue to be worked out, and then it also is in the interest of judicial economy for us to run both of these the same day with the victim once. Okay.
And I would note, Your Honor, just so the court is aware, I did discuss this with him a few days ago regarding this being a potential when I found out about the new case. But unfortunately, Polycom didn't work out yesterday, so I was not able to do the follow-up, so.
Sounds good. Sounds like Polycom's having an issue today
Yeah,
too. So
so we were not able to talk to him as much as that's why I needed to talk to him today, I guess, let me kind of say.
I think he has a question.
Okay. Well, I don't believe, I will ask the court, but I'm not gonna get into it. Okay, all right. Your Honor, there apparently is Mr. Sanderson would like to be heard, I would like to be heard regarding one part of his current conditions of his incarceration. Right, if the court would be willing to listen.
Okay, this is reset to April 3rd at what time?
April 10th.
April 10th. Okay, exam April 10th at what time? At 9. You can address your concern.
Thank you, Your Honor. First off, I think Mr. Enid was wondering if we could also have it set for a PCC next week, same with the other file, or do we?
That's fine.
Okay, thank you. As to the concern, apparently as part of one of his arraignments this past week, his phone privileges at the jail were revoked or blocked. He is asking the court to reconsider that. With regard to being able to make phone calls. I don't have much other information other than that because I only know about this situation from my colleagues who did the arraignment. No.
I remember anybody asking me about this. It says Project Simmons.
Okay.
I vaguely remember, I don't remember any of this. Okay, let's see here. Let me review what he has 3 violations allegedly.
That is my understanding, Your Honor. New file and then 2 phone calls.
Phone calls from jail. Allegations.
I believe that LPD is the allegation. LPD lockup is an allegation.
Oh, well, that's jail. LPD is jail as well. There's allegations that he made calls while in LPD lockup to the alleged protected party. Okay, I see that. Okay, I see the report. What do you think that you're gonna get phone privileges restored?
I didn't call her phone. I called.
Don't.
Okay.
He would maintain his innocence as to that. Is his contention. He did not call her, and obviously
I didn't ask him about it if he called her. I want to know, why does he think he's getting his phone privileges restored if we have pending bond violations?
I don't know what my phone has to do with anything. You know what I mean?
Got it.
I need to call
Okay.
my children and stuff.
Yeah, well, unfortunately, the allegations per this report, there's actually multiple allegations of bond violations. At 3 pending at the same time, which is a reflection that seemingly you have an issue with following court order. And then now we have a new felony that's pending, which is why we reset this. Same victim. While you're out on bond on this case. So for there to be hypothetically or potentially a new case with the same victim, that would mean that there must have been a violation of a no contact order, if true. And then once you're in custody, allegedly, there's phone calls from the jail, which this police report indicate that they were able to confirm or observe 2 outgoing calls to the victim on the phone, and 1 call 1300 hours and 1 was 1315, which would have been while you were in custody of the Ingham County Jail. And so that would be a violation of your bond conditions. And so I don't want you to feel tempted while you're in custody to use the recorded phone calls to make calls that are in violation of your bond conditions, because based on the information I have now, there's a pattern of you being tempted to go outside the realms of your bond conditions. So at this time, until there's a hearing on those bond conditions, or bond violations, we are going to continue the bond asset and continue with your privileges being limited while you're in the custody. It's for your protection. That way you won't have any additional issues. And if you're concerned, sir, about making sure you remain in good quality contact with your children, then you probably want to stop going to jail. Any additional matters for the record?
No, Your Honor.
No, Your Honor, not this time.
Thank you. You're all set.
That is for, not, I'll go and get the stuff regarding. It's a different level. It's a different standard. Let me look into that. Okay? All right, the Judge Jennings, you said? All right, thank you. That's how.